welcome to iExamB, and today in this video I'll be continuing ahead with our mock test series discussion with respect to Companies Act. But before that, do remember to subscribe to our channel and press on the bell icon so that you can stay tuned and stay updated. Do connect with us through this email ID, or you can even call us on this particular number in case if you have any questions, queries, or you want to clarify any of your doubts. Apart from this, do remember to visit our website wherein you will get all the details with respect to the various competitive exams. So stay tuned and stay updated. So moving ahead with our today's discussion, that is with respect to Companies Act, and Companies Act के अंदर आज हम डिस्कस करेंगे various MCQs with respect to management and administration of the company and various other aspects related to that. So moving ahead with our very first question for today's discussion. The first question is, in case of a private company, dash shall be the quorum for a meeting of the company. So basically इस पर्टिकुलर क्वेश्चन को आंसर करने के लिए सबसे पहले आपको पता होना चाहिए कि कोरम होता क्या है. द कॉन्सेप्ट विथ रिस्पेक्ट टू कोरम, इफ यू आर क्लियर देन यू विल बी एबल और यू विल बी इन अ पोजीशन टू आंसर दिस पर्टिकुलर क्वेश्चन. सो कोरम को अगर हम सिंपली समझे तो वो नंबर ऑफ मेंबर्स जो कि प्रेजेंट होने चाहिए एक मीटिंग कंडक्ट करने के लिए. इट इज द मिनिमम नंबर और मिनिमम रिक्वायरमेंट ऑफ मेंबर्स गो अहेड टू कंडक्ट अ वैलिड मीटिंग. सो अगर प्राइवेट कंपनी है तो उस केस में कितने मेंबर्स को कोरम माना जाएगा for going ahead and conducting a valid meeting of the company. And you have various options which are 2 members present, 2 members personally present, 2 members physically present, 2 or more members present, as the company may decide. And the correct option with respect to this particular question is B, which is 2 members personally present, जो कि हमारे section 103 में दिया हुआ है. That is talking about quorum for meetings, and it mentions that अगर एक private company है तो 2 members if they are personally present, that will be considered to be the quorum for the meeting, and so the meeting can be conducted and it will be considered to be a valid meeting. Now moving ahead with our very next question, that is, unless the articles of a company provide for a larger number, in case of a public company, dash shall be the quorum if the number of members as on the date of the meeting is not more than 1000. So पहले हमने देखा quorum requirement with respect to a private company. इस particular question में क्या है? Quorum requirement with respect to a public company, and which mentions कि quorum requirement क्या होगी if the number of members as on the date of the meeting that is not more than 1000, and the various options are available, out of which the correct option for this particular question is B, which is 5 members personally present. So अगर public company है तो quorum requirement 5 members personally present होगी if on the date of the meeting the number of members is not more than 1000. और आप देख सकते हो कि जो हमारा section 103 है quorum requirement से related, उसमें दिया हुआ है कि public company अगर है तो 5 members जो personally present quorum माना जाएगा if the number of members as on the date of the meeting is not more than 1000. Second है 15 members personally present को quorum माना जाएगा if on the date of the meeting the number of members is more than 1000 but it is up to 5000. And lastly 30 members personally present if the number of members on the date of the meeting exceeds 5000. So these are the various quorum requirement if we talk about a public company, and private company को already हमने cover up किया अपने previous question में. Now moving ahead with our next question, that is question number 3, which talks about what should be the gap between one annual general meeting of a company and that of the next. Again meeting से related questions काफी आते हैं एग्जाम में. That is one of the important aspects of Companies Act which is generally asked in the exam, so you have to be very thorough with respect to that. And अगर इस question की हम बात करें तो annual general meeting के बारे में पूछता है कि gap क्या होना चाहिए between one annual general meeting of the company and that of the next. So annual general meeting, as the name itself is suggesting कि क्या है annual general meeting, basically वो आप कह सकते हो yearly meeting है, annual meeting है company की और उसके shareholders की. So gap क्या होनी चाहिए between one annual general meeting and the very next meeting, and the correct option with respect to this particular question is E, which is 15 months. So the gap between the one annual general meeting of the company and that of the next should be 15 months, which is given under section 96, जो कि annual general meeting के बारे में बात करता है और mention करता है कि every company other than a OPC in each year hold in addition to any other meeting a general meeting as its annual general meeting and shall specify the meeting as such in the notice calling it, and not more than 15 months shall elapse between the date of one annual general meeting of a company and that of the other. So only OPC has been given an exemption with respect to that. Otherwise, the requirement with respect to going ahead and having an annual general meeting of the company as laid down under section 96, that has to be complied by the company. So moving on to our very next question, that is question number 4, which is talking about a company shall have its first annual general meeting held within a period of dash from the date of closing of the first financial year of the company, and in any other case within a period of dash from the date of closing of the financial year. So basically इस एक पर्टिकुलर क्वेश्चन में आप देख सकते हो वो दो इंपॉर्टेंट चीजें कवर है. पहला कि जो कंपनी है उसकी फर्स्ट एनुअल जनरल मीटिंग कब होनी चाहिए. सो इट शुड बी हेल्ड विद इन अ पीरियड ऑफ व्हाट फ्रॉम द डेट ऑफ क्लोजिंग ऑफ द फर्स्ट फाइनेंशियल ईयर ऑफ द कंपनी. एंड सब पार्ट ऑफ दिस पर्टिकुलर क्वेश्चन इज आस्किंग कि इन एनी अदर केस विद इन अ पीरियड ऑफ व्हाट फ्रॉम द क्लोजिंग ऑफ द फाइनेंशियल ईयर एनुअल जनरल मीटिंग शुड बी हेल्ड. एंड द करेक्ट ऑप्शन इज सी, which is 9 months is the first one and 6 months is our second correct option. So provision which is laid down under section 96 subsection 1, which says every company other than OPC in each year hold in addition to any other meetings a general meeting as its annual general meeting and shall specify as such in the notice calling it, and not more than 15 months shall elapse between the date of one annual general meeting of a company and that of the other. Provision mentions that in case of the first annual general meeting, it shall be held within a period of 9 months from the date of closing of the first financial year of the company, and in any other case within a period of 6 months from the date of closing of the financial year. Question number 5 that talks about a person can act as a proxy on behalf of members not exceeding 50 and holding in aggregate dash of the company carrying voting rights. So basically again proxy क्या होता है पहले आपको ये पता होना चाहिए. तो proxy को याद रखने के लिए सबसे सिंपली हम समझ सकते हैं representing someone else. You can say person who will be acting as a proxy on behalf of the members that will not be exceeding 50 and holding in aggregate dash of the company carrying voting right. And there are various options which have been laid down with respect to this particular question, and the correct option is D, which is not more than 10% of the total share capital. So not more than 10% of the total share capital is the correct option, which you can find in section 105, which talks about proxies. Provided also that a person appointed as a proxy shall act on behalf of such member or number of members not exceeding 50 and such number of shares as may be prescribed, and this prescribed limit is given under company's management and administration rules 2014, rule number 19, which talks about proxies. A person can act as a proxy on behalf of members not exceeding 50 and holding in aggregate not more than 10% of the total share capital of the company carrying voting rights. Now moving on to our next question, that is question number 6, that mentions a person appointed as a proxy shall act on behalf of such member or number of members and such number of shares as may be prescribed. And the correct option with respect to this particular question is not exceeding 50. ये already अभी हमने जो previous question देखा उसमें इससे रिलेटेड प्रोविजन था. तो आप देख सकते हो कि विद रिस्पेक्ट टू प्रॉक्सी रिक्वायरमेंट ऑल्सो देयर आर टू इंपॉर्टेंट एस्पेक्ट्स. पहला, तो कितने नंबर ऑफ मेंबर्स को बेसिकली प्रॉक्सी रिप्रेजेंट कर सकता है. सो इट मेंशंस नॉट एक्सीडिंग 50 एंड सच नंबर ऑफ शेयर्स एज मे बी प्रिस्क्राइब्ड. नाउ द नेक्स्ट क्वेश्चन, दैट इज क्वेश्चन नंबर 7, दैट टॉक्स अबाउट हु इज एंटाइटल्ड टू अपॉइंट अनदर पर्सन एज अ प्रॉक्सी एज पर द कंपनीज एक्ट. अब ये जो प्रॉक्सी है रिप्रेजेंट करेगा 50 मेंबर्स और द रिक्वायरमेंट विद रिस्पेक्ट टू शेयर्स को अगर फुलफिल किया जाएगा तो प्रॉक्सी रिप्रेजेंट करेगा किसे. So basically this question is asking the persons who are entitled to go ahead and appoint another person as a proxy, and the options are any person of a company entitled to attend a meeting of the company, any member of a company entitled to vote at a meeting of the company, any member of a company entitled to attend and vote at the meeting of the company, any person of a company who is not entitled by the articles to attend and vote at the meeting, person who the company shall decide to have such right and his name is included in the articles of the company. So आप देख सकते हो almost when you are going through the MCQs you can find that there are very near and confusing options which are being provided to you. So when you are starting any of the concepts or provisions, you have to be very thorough with them. We talk about this particular question. The correct option with respect to this question is C, which is any member of a company who is entitled to attend and vote at the meeting of the company is entitled to go ahead and appoint another person as a proxy. जो provisions हमारा प्रॉक्सी से रिलेटेड है, सेक्शन 105 में कवर्ड है। सबसेक्शन 1 मेंशन करता है एनी मेंबर ऑफ अ कंपनी हु इज एंटाइटल्ड टू अटेंड एंड वोट एट द मीटिंग ऑफ द कंपनी इज एंटाइटल्ड टू अपॉइंट अनदर पर्सन एज अ प्रॉक्सी। नाउ द नेक्स्ट क्वेश्चन इज इफ at the adjourned meeting also a quorum is not present within half an hour from the time appointed for holding the meeting, what will happen? The meeting shall be cancelled, the meeting shall be rescheduled, the meeting shall be adjourned, members present shall be the quorum, the minimum number of 2 members present shall be the quorum. And the correct option with respect to this question is B, which is the members present shall be the quorum. Section 103 में quorum requirement जहाँ पे बात की गई है उसमें provision है कि if at the adjourned meeting also a quorum is not present. So basically for want of quorum and all, if a meeting is adjourned and if at the adjourned meeting also the quorum is not present within a period of half an hour from the time appointed for holding the meeting, the members present they shall be considered to be the quorum. Then in that case जितने भी members वहाँ present होंगे उन्हीं को quorum माना जाएगा और meeting conduct किया जाएगा. So this is with respect to the adjourned meeting quorum requirement. Now question number 9 that talks about who has the power to call the extraordinary general meeting of the company. So if we talk about extraordinary general meeting, who has actually the power to go ahead and call this particular meeting of the company? And the various options are members, chairperson, secretary, board, none of the above, and the correct option is board, which is given under section 100 subsection 1. The board may whenever it deems fit call an extraordinary general meeting of the company. So extraordinary general meeting जो है board basically बुलाती है. Now the question number 10, which is the last question for today's discussion, what is the time period for the notice of general meeting of companies? So basically जो notice देनी होगी for going ahead and conducting the general meeting, what is the time period for that particular notice? And the various options are 24 days, 14 days, 21 days, 44 days, and none of the above. And the correct option is 21 days, which is option C, given under section 101 subsection 1, which says a general meeting of a company may be called by giving not less than clear 21 days notice either in writing or through electronic mode. So with this we come to an end of our discussion with respect to the various MCQs related to the management and administration of the company. In my very next video also I'll be continuing ahead with Companies Act and I'll be discussing the various mock tests related to that. So till then do remember to subscribe to our channel and stay tuned so that you can stay updated.